Thank you, Mr. Chairman.
Dennis O'Rourke.
Thank you, Mr. Chairman. I want to first respond to the criticism of my speech in the second reading of this bill by the Green Party and also now by the Honourable Member Chris Aukenvold of the National Party, the sponsor of this bill. The criticism was that having welcomed the bill on its introduction, I and New Zealand First are now opposing it. Initially, the bill appeared to be making a practical improvement to the way habeas corpus applications were dealt with by the courts. So I and New Zealand First supported the bill to the committee stage for scrutiny there. That scrutiny has shown the bill as introduced to be significantly defective. So New Zealand First will not now support it. And Mr. Chairman, I don't see anything at all illogical about that. In fact, I would say that the Green Party criticism and Nationals criticism both appear to be a rather pathetic excuse for the fact that both of those parties now have no good argument to continue to support this bill. In the end, the bill in fact does next to nothing to improve the habeas corpus procedure. It is now amended almost out of existence. In fact, the bill is a substantial waste of the House's time, I believe.
Well, don't waste it anymore.
There were 5 major defects. First of all, Clause 5 of the bill has been amended to ensure that only a judge would have the power to direct that another matter take precedence over a habeas corpus application or an appeal in respect of one. As introduced, the bill would have allowed courts or their judges to make decisions. So the amendment is now that because of the interpretation of the word court, only judges are able to do that. Now, that is hardly worth a special bill in this House to do because there is no real change from the status quo. Secondly, Sub-clauses 2 and 3 of Clause 5 of the bill as introduced have been removed so that we now retain the 3-day time frame within which habeas corpus applications must be heard. And New Zealand First, of course, supports that. The bill as introduced would have allowed a judge to extend that period, but the Select Committee found that, and I quote, "There is little evidence that the current time frame is problematic," unquote. Having looked closely at the issue as part of that Select Committee process which the member referred to, I can only agree with the committee's conclusion. And what that means is that the basis for the bill has really proved to be completely unnecessary. In other words, the bill should not have been considered really in the first place. Thirdly, as the Select Committee said, quote, "Extending the time frame could expand the court's jurisdiction regarding habeas corpus, potentially leading it to determine matters that might be more appropriately dealt with by another procedure. This could have the unintended consequence of removing current rights of appeal," unquote. So again, the Select Committee recommends instead of what the bill says, actually the status quo. So again, the bill has been found wanting in a very fundamental way. Fourthly, Clause 6 has now been removed because, as introduced, the clause would allow a judge to convene a conference of the parties to determine how proceedings would advance, including whether appearances would be made by remote means. The Select Committee found that, quote, "In effect, this provision restates the High Court's existing rules," unquote. So, once again, the bill actually is a complete waste of time, adds nothing in that respect, and achieves nothing new. Fifthly, Clause 8 of the bill has been removed and replaced by a new clause to the effect that the provisions of the Court's Remote Participation Act 2010 apply to habeas corpus proceedings, which of course is the case, Mr. Chairman.
Dennis O'Rourke.
Which of course is the case anyway, and is precisely why the Act was passed in 2010. And I have to wonder whether Mr. Auchinvoll actually knew that that Act had been passed, because if he had, why would he be including in this bill something that was already achieved not long ago in 2010 by way of the Court's Remote Participation Act 2010. Therefore, the inclusion of that provision in this bill was, yes, just another waste of time. The Select Committee said, and I quote, "We think that having different requirements for audio-visual links in the Principal Act and in the Court's Remote Participation Act could lead to confusion," close quote. So this provision in the bill is actually counterproductive and should not be supported. So not just a waste of time, actually retrograde, actually undoing some good. So, Mr. Chairman, in the end, we see that all of the main provisions of the bill are actually removed. Clause 5 has been amended to clarify that a registrar cannot make the decision under Section 19(1) of the Habeas Corpus Act. Well, big deal, no real change. Clause 6 is removed because it restates the existing High Court rules. Again, big deal, no real change. Clause 8 is removed because the Court's Remote Participation Act 2010 has been passed. So we are actually left with nothing much at all in this bill as it now stands. In fact, only Clause 7 now stands, simply to confirm that the High Court can refuse an application because habeas corpus is not the proper procedure. In fact, that is something the court can already do. So in the end, the bill is not proved really to be worth the House's time. New Zealand First supported the bill's referral to the Select Committee because we think it is fair and proper that a private member's bill, where it appears may have some value, should be scrutinised by the committee. But the committee has effectively amended it out of existence. New Zealand First was part of that process, so rather than resile from it, as Mr. Auchinvoll suggested I perhaps should, I embrace it. I was part of the process. I assisted in finding these defects. I therefore now, on New Zealand First's behalf, say that it is no longer necessary to have this bill at all. The correct procedure then is to vote against it. So, Mr. Chairman, New Zealand First will now vote against it as being a substantially unnecessary piece of work.
The question is that clauses 1 to 5 and clauses 7 to 12 stand part. Those of that opinion will say aye. Contrary, no. The ayes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes in favour.
New Zealand Labour.
34 votes in favour.
Green Party.
14 votes in favour.
New Zealand First.
7 votes against.
Māori Party.
2 votes in favour.
Mana.
1 vote in favour.
ACT New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan.
1 in favour.
The ayes are 113, the noes are 7. The motion is agreed to. I will report this bill without amendment.
Members, the House is resumed. Mr. Chairman.
Mr. Speaker, the committee has considered the Habeas Corpus Amendment Bill and reports it without amendment. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. To the contrary, no. The ayes have it. The bill is set down for third reading next sitting day. Call on members' order of the day.